friends, in this session I will talk about constitutional safeguards for civil servants. The basic objectives of the session are to study the constitutional safeguards available to civil servants, understand the need and importance of these safeguards, and appreciate the legal principles laid down by courts regarding conditions of service of civil servants. Civil servant is indispensable to governance of the country in the modern administrative age. Ministers frame policies, legislature enact laws, but the task of efficiently and effectively implement these policies and laws falls on the civil servant. The Constitution therefore seeks to inculcate in the civil servant a sense of security so that he is able to function efficiently and give his best to the country. Article 309 to 323 of the Constitution make elaborate provisions for the central and state services. You all will agree that the service jurisprudence in India is rather complex. It is intertwined with legislation, rules, directions, practices, judicial decisions, and with principles of administrative law, constitutional law, fundamental rights, and natural justice. Therefore, the role of court in this area is crucial, as they seek to draw the balance between twin needs of civil services: the need to maintain discipline in the ranks of civil servants, and secondly, the need to ensure that the disciplinary authorities exercise their powers properly and fairly. Let us first see what the term civil servant means. It includes members of a civil service, of the centre or a state, or of an all India service, or all those who hold civil post under the centre or the state. A civil post means an appointment or office on the civil side and includes all personnel employed in civil administration of union or state. The relation of master and servant between the state and the employee is necessary. However, it does not include a member of a defence service or even a civilian employee in defence services who is paid salary out of estimates of Ministry of Defence. These persons, therefore, while falling under Article 309 and 310, do not enjoy the protection of Article 311. A member of police force, however, is a civil servant. Now let us see what Constitution provides for public and civil servants. According to Article 309, the legislature has been empowered to frame rules regarding recruitment and condition of service of all persons appointed to public services and posts in connection with affairs of union or state. The proviso to this article further provides that until such legislation is enacted, the President or the Governor or any person authorized by him may make rules in this respect, and accordingly service rules for various services have been enacted by government. The Article 310 talks about the pleasure doctrine. The first clause lays down the defence person and civil servant of union and the members of all India service hold office during the pleasure of the President. Similarly, a civil servant in the state hold office during the pleasure of governors. These pleasure doctrine have been imported from England. In Britain, traditionally, a servant of a crown holds office during the pleasure of the crown. The tenure of office of civil servant, except where it is otherwise provided by the statute, can be terminated at any time at will without assigning any cause, without notice. The civil servant has no right to take recourse to the courts or claim any damages for wrongful dismissal. The justification for doctrine of pleasure is that Crown should not be bound to continue in public service any person whose conduct is not satisfactory. However, this general rule which operates doctrine of pleasure is subject to general constitution limitations. Therefore, when there is a specific provision in the Constitution giving to the servant tenure different from that provided in Article 310, then that servant would be excluded from the operation of doctrine of pleasure. The Supreme Court judges, Auditor General, High Court judges, a member of a Public Service Commission, the Chief Election Commissioner have been expressly excluded by Constitution from the rules of pleasure. The doctrine of pleasure as developed in England has not been accepted in full in India. It is subject to provisions of Article 311 which lays down procedural safeguards for civil servants. Besides this, the doctrine of pleasure is further restricted by general law of the land, which empowers any civil servant to file a suit in court of law for enforcing any condition of service. Clause 2 of Article 310 empowers government to enter into service contracts as well with persons having special qualification. The pleasure doctrine cannot be qualified by such agreements. Let us see the safeguards provided under Article 311 of the Constitution. The Article 311 provides for many safeguards to civil servants against any arbitrary dismissal from their post. Firstly, no person holding a civil post shall be dismissed or removed by authority subordinate to that by which he was appointed. This does not mean that the removed or dismissed must be by the same authority who made the appointment or by the direct superior. It is enough if the removing authority is of the same or coordinate rank as the appointing authority. Second, the article provides that no civil servant can be dismissed, removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard. Originally, the opportunity to defend was given to the civil servant at two stages. First, at the inquiry stage, second, at the punishment stage. However, the Constitution 42nd Amendment Act has abolished the right of the government servant to make representation at the second stage of the inquiry. The newly added proviso to Article 311 makes it clear that if after inquiry it is proposed to impose upon a person any of the three punishments will be imposed on the basis of the evidence adduced during the time of inquiry of the charges against the government servant only. As I have already discussed, the expression civil post means appointment on civil side of the administration distinguished from military side. The safeguards under Article 311 are thus not available to the members of defence forces or any post connected with defence. Civil post signifies there must exist master-servant relationship. Protection of Article 311 applies both to permanent and temporary employees. However, it does not apply to compulsory retirement in public interest, termination of service during probation or termination of service which is temporary and for fixed period. Further, the protection of Article 311 is available only when the dismissal, removal or reduction in rank is by way of punishment. The main question therefore is determine as to when the order of termination of service or reduction in rank amounts to punishment. The Supreme Court has laid down two tests to determine whether the termination is by way of punishment. First, whether the servant had a right to hold the post or the rank. Secondly, whether he has been visited with evil consequences or not. As regards the suspension is concerned, it is neither dismissal or removal or reduction in rank. Therefore, if a government servant is suspended, he cannot claim the constitutional guarantee of reasonable opportunity. When the services of a government servant are terminated for bona fide reasons as a consequence of the abolition of the post held by him, Article 3112 need not be complied with. The second proviso to Article 311 Clause 2 lays down three situations where the rule does not apply: where a civil servant is dismissed or removed or reduced in rank on the ground of conduct which has led to his conviction on criminal charges, or where the competent authority is satisfied that for some reasons to be recorded by it in writing, it is not reasonably practicable to hold such inquiry. In deciding whether holding of an inquiry is not practicable, the test of a reasonable man taking a reasonable view is to be applied. The third condition is where the president or the governor, as the case may be, is satisfied that in the interest of security of the state, it is not expedient to give to the civil servant such an opportunity. So friends, in this session I have tried to give you a synoptic overview of the safeguards available to civil servant. With this brief discussion, I end my session and leave you with a few questions which you find interesting and easy. Thank you all for watching this video.